It is the dope dad himself on National Cabbage Day, Rico Lamitte.
Oh yeah, Jason. So I have a story that hopefully Roz McCarthy is going to be joining me on for this one. She said she's in the back room, so definitely because I don't want to speak erroneous on this one. But it's coming from Health News Florida by Dara Kim. Judge sides with the state on black farmers medical marijuana license and deceased grower case in Ocala, Florida. So, farm and rancher Moton Hopkins was among dozens of applicants for state licenses earmarked for black farmers recognized as class members of a class action lawsuit win over racial lending discrimination by the federal government. The Florida Department of Health officials gave Hopkins' applications the top scores of the batch, but his application was ultimately rejected because he died before the process was complete. His heirs and partners challenged the decision, arguing that the state illegally relied on an unpromulgated rule in denying the license. But this Tuesday, State of Florida Administrative Law Judge Gary Early upheld the decision. In a response to public outcry, Early wrote this: not to be overly simplistic, but the only material fact bearing on this case is whether any of the petitioners listed in the style of this proceeding are a recognized class member of the reference litigation. They are not. The only recognized class member was Moton Hopkins individually, and he is deceased. Thus, there is no living applicant to whom the license may be issued. A 2017 law provided framework for medical cannabis requiring health officials issue licenses to people with ties to class action Pigford litigation. After years of public backlash from black farmers, local activists, and cannabis advocates, state health officials finally began accepting applications for the black farmer license March 2022, well after the medical industry had taken off in Florida, leaving the Pigford class farmers years behind the corporate entities they'd soon have to compete against. In a January administrative complaint filing, Hopkins' lawyers argued the license should go to the entity, not the individual affiliated with the application. The lawyers even asked Early to determine whether health officials erroneously relied on an unadopted rule that licensure qualifications are personal to Hopkins. Thomas Sosnowski, the lawyer representing the Hopkins applicant, said Early's ruling is expected to be appealed to Tallahassee-based First District Court of Appeals, and noted during a hearing on Friday, an attorney representing the Department of Health likened the black farmer's cannabis license to a plumber's license. As we'll argue on appeal, the department's interpretation that the Pigford license is like a plumber's license, and Judge Early's ruling agreeing with the department, that calls into question the entire Pigford license provision in the statute because, as we'll explain in our appeal papers, that interpretation is unconstitutional. A 2016 constitutional amendment authorizing medical cannabis in Florida says a licensed medical marijuana treatment center must be an entity, he argued, pointing to a separate ruling by the First District in a case rejecting a Tampa man's attempt to grow his own medical marijuana. Our position is that the Constitution provides that MMTC or medical marijuana treatment center licenses need to go to entities. So the interpretation of that statute permitting or requiring an MMTC license to go to an individual, a natural person, or position is that it's not authorized by the Constitution. So, Roz McCarthy, she actually is intimately involved with this one. You want to help us out on this? What's going on there?
Hey, Rico.
What's up, Roz?
I know. Can you hear me?
Yeah,
Yes, yes.
going
Go
on
for it,
in
Ross.
the state of Florida?
Hey, Jason and Rico. It's been a minute. So happy to hear you guys, and so
Good to
happy to
hear
be
you.
on. And yeah, so listen, the issue is in the state of Florida.